Our next speaker, without any further ado, we'd like to introduce Mr. Amit Desai. Thank you very much, Mr. S.V. Raju, for your comments there. Thank you very much. Yes. And our next speaker is Mr. Amit Desai.
Absolutely.
Rhythm.
And he is the senior advocate in the Supreme Court, Mr. Amit Desai. Mr. Desai, a third-generation lawyer walking into the footsteps of his famous father, late Shri Krishnakant Desai. He's also, Mr. Desai himself has worked in close proximity with stalwarts of the Indian jurisprudence,
including the likes of Mr. Nani Palkiwala, Fali Nariman, and yes, of course, none other than Mr. Ram Jethmalani himself. Senior advocate Amit Desai is today, without doubt, a leading figure in the Indian legal community, renowned for his expertise in criminal law with decades of experience, which makes him an ideal speaker to the Ram Jethmalani Memorial Lecture Series as we discuss in detail the implications of the 3 new criminal statutes and whether they meet their intended objects and expectations. Without any further ado, I welcome you, Mr. Amit Desai, to present your insights.
The Honorable Home Minister, Mr. Ram Jethmalani, Goswami, my dear friends and colleagues at the bar, and the audience of laymen, intellectuals, and lawyers. Mahesh, thank you for giving me the privilege to speak on the momentous occasion of the 101st birth centenary of the Bhishma Pitama of criminal law in India. This occasion is made even more significant as in this 75th year of our independence, we now have the reenacted 3 criminal laws effective from July 2024. But before sharing my thoughts on these 3 laws, I wish to say a few words about Ram Jethmalani. Ram would have been 101 years old today. Ram was a household name to me since my late father, Krishnakant Desai, a senior advocate, was a close contemporary of Ram in Mumbai. The 3 brilliant minds at the criminal law bar in Mumbai from the 1950s to the 1990s were Ram, Krishnakant Desai, and Feroz Vakil. And those were the times when trials were conducted daily and the trial courtroom was a vibrant battlefield. Ram, a prodigious student, born in 1923 between the 2 world wars, entered the legal profession in a tumultuous era of the freedom struggle. Having been born in Sindh in Pakistan, he experienced the pain of the partition of India and Pakistan. He also witnessed the drafting of the Indian Constitution and the birth of the Supreme Court of India. The cataclysmic events of the first half of the 20th century surely shaped Ram's liberal thinking. Ram's dharma and karma were preordained. The rule of law ran through every vein in his body, and he used his intrinsic knowledge of law and history to achieve political status and influence political outcomes, some of which were mentioned by the Honorable Home Minister. His liberal thinking, his unwavering commitment to protect liberty in its broadest sense, and his deep sense of justice for all brought Ram, once a penniless lawyer, into the thicket of criminal law, a law both used and misused during our freedom struggle. India's fight for freedom was at a critical juncture. Between the 2 world wars, with the then recent introduction of the criminal law triumvirate, which is the Indian Penal Code of 1860, the Criminal Procedure Code of 1898, and the Indian Evidence Act of 1872, the Indian courts were flooded with cases of sedition and conspiracy aimed at overthrowing the British rule. Some of the most memorable sedition cases were those of Bal Gangadhar Tilak and Mohandas Karamchand Gandhi. The conspiracy cases that captured the public's imagination included the Meerut conspiracy case, Dhaka conspiracy, Muzaffarpur conspiracy, and many more. And you will realize why I'm giving you context of this. Ram's birth, a few years after the Rowlatt Act of 1919, which was introduced to curb the growing nationalist movement by giving police the power to arrest without reason and detain without trial, and the events that followed, including leading to Gandhiji's rise to prominence, must have shaped Ram's destiny to enter the world of criminal courts. Ram's legal and political career has been spoken of and written about extensively over the years. Today, Ram lives on as an idea, the idea that is Ram Jethmalani. What is this idea? What is this idea of Ram? It's an idea that embodies fearlessness, personal liberty, free speech, innovation, the rule of law, equality, pro bono service, and justice. But the question we have today is, have these ideas found their place in the new laws. Let's first talk about liberty. In recent years, there's a public perception that the criminal justice system has shifted from punishment by conviction to punishment by arrest and custody. The Supreme Court has been struggling to balance liberty rights. But has the BNSS addressed these evolving issues regarding the powers of arrest, remand, and bail adequately? The BNSS, Section 47, does not clarify the requirement that the grounds of arrest must be communicated in writing at the time of arrest. The BNSS, Section 187, modifies the provisions of remand, but does not provide that the magistrate's first duty is to ensure that all constitutional and statutory obligations are fulfilled before the accused is produced. And if those duties are not met, the accused should be immediately released. These principles having been established by the Supreme Court in Anesh Kumar and more recently reaffirmed in Satinder Until. Another concerning change is in regard to police remand. My learned friend, Mr. Raju, just talked about it. The period of police remand initially was limited only to 15 days at the first stage of production of the accused before the magistrate. It is now any 15 days within the initial 40 or 60 days, depending on the punishment for the offense. This reverses the judgment in Anupam Kulkarni, where Ram successfully limited police remand to the first 15 days after arrest. But why is this remand restricted? My learned friend, Mr. Raju, had something to say about it. The 15-day period was always intended to protect the accused from methods which will be adopted by some overzealous and unscrupulous police officers. This modification in the new law may lead to the abuse of the process by such overzealous and unscrupulous officers, as courts of first instance could extend remands to at least 40 to 60 days as a matter of practice, allowing the police to manipulate and prevent early release by seeking intermittent custody. Mr. Raju made a comment to say that, well, the accused can be summoned at any time by the police, and that's the reason why there is a need for this extension. But that is never the principle of law that was ever established while protecting liberty of accused. We are not intended to be in a police state. However, this new chapter, these new changes appears to shift the protective approach of the courts in the past. They threaten the Supreme Court's consistent message to courts of first instance to follow the rule of law, that is bail, not jail. The new definition of custody in the BNSS also raises concerns. Custody under the remand provision is now defined as custody in a police station or prison. So time spent outside a police station for investigation, examples are during recovery of evidence, or time spent in a hospital, or time spent on a custody parole, or under house arrest, or otherwise outside a prison, does not count as custody within the meaning of this provision. This negates the Supreme Court's efforts to liberate accused from the weaponization of custody and impacts the calculation of the number of days in relation to the right to default bail under this section. And I think everybody understands the intent of that. The Supreme Court's recognition of house arrest, as in the Gautam Navaka case, a great progression that was made by the Supreme Court, may no longer be feasible. For these seemingly minor changes, if Ram was here, his booming voice would have said, these changes remind me of the police powers of pre-independence India. They turn back the clock on our efforts to gain independence and undermine the Supreme Court's efforts to protect personal liberty rights. In 2006, following years of strictures by the Supreme Court, incarcerated accused awaiting trial found relief through Section 436A of the Code, which Mr. Raju just adverted to, which introduced a distinct default bail right alongside the original right under 167 of the erstwhile Code. However, in the new provision, under Section 479 of the BNSS, this right has been significantly restricted. Offenses punishable by life imprisonment are now excluded from this particular provision. And now there are 60 such offenses which are punishable with life imprisonment. Moreover, if investigations are ongoing in more than one offense for the same accused, this right is excluded regardless of the quantum of punishment. Given our overcrowded prisons, with a total inmate count in excess of 5,73,000 and an overcapacity of 131%, these provisions need some urgent reconsideration. I believe liberty has been compromised in our journey towards a better society. This brings me to another aspect of the legislations. This is punishment and commutation. The offences punishment by the death penalty have increased by 20%, and life imprisonment for the entire natural life has increased by nearly 50%. We seem to be moving towards a retributive form of punishment instead of being reformative. The Supreme Court has, over the years, been reducing the number of cases in which death penalty is imposed. The ever-escalating debate of reformation under the Article 21 Doctrine of Liberty and its compatibility with death penalty resulted in the death penalty being imposed only in the rarest of rare cases, and only when the alternative option of life imprisonment was unquestionably foreclosed. However, we have 20% more offences awarding the death penalty. The offence of imprisonment for life, that is rest of the natural life of a person, is another form of meting out effectively the death penalty, since there is no remission for this punishment. Once a court passes a sentence for the entire natural life, it has effectively condemned the prisoner to the death penalty. It takes away any hope of release for good behavior, repentance, rehabilitation, reformation, age, health, etc. And by increasing the number of sections to which these egregious forms of punishment is made applicable, we are widening the net instead of the reformist direction of the Supreme Court in not awarding these punishments except in extremely rare situations. Commutation. The philosophy of commutation is grounded in the belief that public welfare will be better served by inflicting less than what the judgment fixed, recognizing the value of mercy in governance. Every civilized country recognizes this and has therefore provided for such power to be exercised as an act of grace and humanity in proper cases. Without such a power of clemency, a country would be most imperfect and deficient in its political morality. The 1973 Code allowed a broad discretion to commute any sentence to any lesser sentence so that you can reduce a life imprisonment to even a shorter term or even to fine. But the new legislation, the BNSS, restricts this discretion. It introduces what I call a staircase system, allowing only a one-step down commutation, that is from death penalty to life imprisonment and no further, or from life imprisonment to no less than 7 years, and so on and so forth as provided in the section. This restrictive approach takes away the discretion of the state to show its mercy, grace, or humanity in a given case. Let's take another aspect of this legislation. One of the other concepts introduced by the BNSS, which potentially takes away liberty, is the ability to conduct a trial and render a conviction against an accused and sentence him in absentia. Previously, the code only provided for trials in absentia to protect the evidence of various witnesses until the accused was found and brought before the court. Now, Section 356 provides for a complete trial, a judgment of conviction, including the imposition of punishment in the absence of an accused. This raises significant due process concerns. To obviate the obvious natural justice issues, it provides for a legal aid lawyer to such an accused. But in a criminal trial, where witnesses must be cross-examined, it is impossible for a lawyer to represent the accused without any communications with him or instructions from the client. Sexual offenses and rape. The offense of rape continues to resonate deeply within India's consciousness. Each time a case shakes public awareness, laws have been amended to increase punishment, whether in 1983, 2013, 2018, and now in 2024. However, the Ajmer case, the Delhi case, and now the Calcutta case are all reminders of the fact that the inadequacies lie not in punishment, but in investigation and the speed of trial. So have we strengthened these processes sufficiently? The BNSS attempts to address this by increasing the number of doctors who can conduct medical examination and also setting deadlines for the reports of such medical examination Mr. Raju mentioned. Though the BNS the Nyaya Sanhita, like the Nagrik Suraksha Sanhita, like the Criminal Procedure Code, provides for deadlines to complete such investigations and trials, but it ought to have provided for administrative and penal liability for not completing them in time. Introducing administrative or penal action for law enforcement officers or administrative action for judicial officials who fail to complete proceedings within the prescribed time frame would have indeed helped ensure greater accountability, and that is the need of the hour, as we all understand. Let's now talk about gender-neutral laws. As Indian courts have evolved to protect the LGBTQ plus community, there was a pressing need for gender-neutral sexual offense laws. However, when it came to drafting the sexual offences laws, the BNS missed the opportunity. Offences are still gendered. An offender of a sexual offence can only be a man and the victim a woman. Section 377, which everybody would be familiar with, which protected members of the same sex from sexual assault and which penalized bestiality, has not been reenacted. Today, the LGBTQ plus community is at risk inasmuch as sexual assault against partners is not a crime. Even as of June of this year, we read of Suraj Revanna, the MLC from Karnataka, being charged with sexually assaulting a male party worker, which clearly indicates a need to keep the offence on the statute book. Courts have also recently recognized this lapse and expressed the need to urgently amend the law. The BNSS, for the first time, has recognized transgender persons as a distinct gender. However, the transgenders are at as much risk of sexual offences as anyone else. But they are not included in these offences as victims or as accused, and today, any sexual assault on them is not a crime. Terrorism and organized crime. Both are now in the BNS. The offences are bodily lifted from the UAPA and the MACOCA with minor tweaks. Terrorism in the BNS includes economic security, but this term is not defined. Without a definition, considering the width of the phrase, any form of financial activity could, at the whim of a police officer, be categorized as financial terrorism and be included within economic security. So, could the recent Hindenburg shorting of shares on the Indian Stock Exchange, leading to loss of about $100 billion in the market value, constitute economic terrorism? Another new offense is the offense of organized crime. Although it's bodily lifted from the MACOCA, the BNS has made an addition. It includes economic offenses within the definition of organized crime. Economic offenses have been defined in the section to include the like of criminal breach of trust, forgery, or defrauding a bank or a financial institution for obtaining monetary benefit. So what was always a violent crime now includes the passivity of a commercial fraud. Business community and investors need to be cautioned. Bringing terrorism and organized crime under the BNS, and whose investigations and trials are now governed by the BNSS, these heinous crimes against the sovereignty and integrity of the nation have been tempered. There are no twin conditions for bail. There is no provision for extending remand beyond 90 days. There are no specific procedures for call interceptions. And there is no admissibility of co-accused statements recorded by senior designated police officers. Also, there is no protection to a victimized accused since there is no provision for sanction to investigate or prosecute. Investigations are now by local police officers and not by specialized officers of the NIA or the CBI. This change probably believes that terrorism and organized crime activities as threats to nation are waning and are no longer in need of specialized provisions and agencies. I do hope it is so. There's an interesting offense called of attempt to suicide, which has now been introduced. BNS also creates a new offense of attempt to commit suicide. The offense has the mens rea to compel or restrain a public servant from discharging his official duty. Political dissent through hunger strikes have been used throughout our history, be it the hunger strikes of Gandhiji against the British or Anna Hazare during the India Against Corruption movement or against the Haryana government to release water. All of these could now be brought under this section. Before concluding, a quick comment on the Bharatiya Sakshya Adhiniyam, which is the statute which has been altered the least. The significant update is a broadened definition of what constitutes a document. Though there isn't much change in the statute itself, there will be significant issues of how we are going to prove relevant and admissible evidence, given our lives are substantially being lived in the digital world of deepfakes, hacking, and digital fabrications. Much can be said of these three laws, favorable and unfavorable. These legislations will keep the criminal law bar preoccupied for years to come. But if Ram was in our midst today, I'm sure he would have said, and I would like to quote, "The biggest enemy of the criminal justice system is not the criminal. It is the apathy of the people running it." Close. To ensure that the new laws reflect Ram's idea of liberty and equality, we must remain vigilant in our pursuit of justice. Well, thank you once again, Mahesh, and the entire team for this opportunity that you've given me on this occasion.